if you're here, if you're here with us, we have removed House Bill 905 from today's agenda. And it is 4:01. We're going to go ahead and get started. Representative Bodie, if you wouldn't mind, could you open us up in a word of prayer?
Yes.
Thank you. Which number are you? 28.
28. God, thank you for this opportunity today to hear legislation that will affect all Georgians and allow us to go through with due diligence and looking at this legislation before us and examining it. And thank you for everyone in this room. May you keep them safe and hold their families high and also their loved ones. And thank you for this opportunity to serve the citizens of Georgia. Amen.
Amen. Thank you. First up, we have House Bill 906. Chairman Nix, who's actually a ex officio member. I believe you can sit right there and present if you'd like. If you'll just hit your little button there. Chairman Nix.
Thank you. Thank you, Mr. Chairman. As I brought to the committee when we met the first time, this is kind of outside my expertise, and was looking for some opportunities here to put a little teeth into our laws related to these people who are out on our public spaces with their dirt bikes and their four-wheelers and causing all kind of problems in traffic. And my example was having them out running up and down the very narrow sidewalks in Little League baseball with kids all around, and they're doing wheelies and run around. So what we were trying to do is come up with something that would maybe be able to hold the bike or something until something could be done. They're not easy to catch. Once we catch them, we'd like to have some teeth in it so that we could make it hurt a little bit to make them come back. So Mr. Chairman, I'm going to let you kind of explain it a little bit, but the LC 480536S was what was proposed as a means to accomplish what I want to. And if you would kind of give the legal explanation for that, I would greatly appreciate it.
Yes, sir. As I understand it, and I may have Jill Travis with GAC to assist me with this, but I appreciate the chairman's efforts on this and getting with all the interested parties. And basically, this was a tool that we wanted to provide our law enforcement with, making sure that they had the ability to actually make sure that those who are using these vehicles can no longer be able to use them upon an arrest, charged with and convicted of either one of these code sections that we have here in the bill. So this language, I believe, reflects the will of the committee and what we had went through before. So at this time, Miss Jill, if you want to say anything on the bill, I mean, I know we've spoke about this at length beforehand, but if you want to speak to it real quick, we'd welcome your expertise on the matter.
Good afternoon, Mr. Chairman, members of the committee. My name is Jill Travis. I'm the Executive Director of the Georgia Association of Criminal Defense Lawyers. I will say that generally speaking, my organization is opposed to forfeiture, and I will leave out all the reasons for why. But I think that Chairman Nix's bill, LC 480536S, is a fair compromise in the forfeiture field. I didn't realize, I was looking at it quickly before, there's one possible phrase that I might ask you to consider including, which would be on line 19. After the word proceedings, I'm going to say it out loud. I'll repeat it in a moment, and then I'll tell you why. The phrase would be including the requirements set forth in code section 9-16-7. And I think that that's needed to be explicit with regard to timelines that take place in civil forfeiture proceedings, so that The language of the bill actually does say that civil forfeiture is stayed until the criminal proceedings are completed. But I think it would be, it might leave the reader a little bit in the unknown, and the enforcer, which would be the prosecuting attorney. And I'll just repeat that for you again. It was after that civil proceedings on line 19, I put a comma after proceedings and insert the words, including the reporting requirements set forth in code section 9-16-7, comma.
Chairman Nix, would you be amenable to that change?
Yes.
Okay.
And I'm sorry, one more. I think it's just a spelling or typing error on line 19, where it says during pending. I think it's supposed to say during the pendency of the criminal proceedings, not during pending. During the pendency of the criminal proceedings. Because during pending doesn't make sense.
Seems as if Chairman Nix is good with that. All right. Any discussion from members of the committee on this proposed amendment to the sub? And just for clarification, we're operating off of LC 480536S. Any discussion? All right. You have the amendment before you to the sub. I'll entertain a motion for that amendment. Oh, yeah. Mr. Chair, I was wrong on my procedure there. We're not in that posture yet. And before I get further on this, do we have any discussion from anyone here in the audience? Pack, do y'all want to weigh in? All right. Neil, Neil Herron. Hold on. You can stand at the podium, come to the table, whatever you'd like.
Thank you, Mr. Chairman. I'm Neil Herring, Georgia Chapter of the Sierra Club, representing Georgia Forest Watch and Flint River Keeper. This may well address Mr. Nix's problem in town, and my problems are all out in the country. And what I would really like to do is be able to allow law enforcement to impound off-road vehicles where a violator has done unpermitted, mechanized, land disturbing activity on the property of another. That should be illegal, and they should be able to impound the vehicle. I'm convinced that a code citation on a sign and 3 or 4 impoundments would end many of our problems all over the state. And I believe that those provisions could be inserted in here. I mean, I could do it right now if you want me to, but you could just add impoundment. May be impounded is declared, such vehicle is declared to be contraband and may be impounded and subject to forfeiture. And then the phrase by a person who's arrested, charged with, convicted of violation of section, or who conducts unpermitted, mechanized, land disturbing activity on the property of another is declared to be contraband. And then the previous stuff. I realize that I'm late here, and I'm sorry that I'm proposing this so abruptly, but that would resolve the problems that we've got in the national forest and we've got in the rivers down in the flatwoods.
Representative Bodie.
Yes, thank you so much. Thank you. Thank you so much for bringing that point. I completely understand. I just want to make sure, and all these astute lawyers we can figure this out. If we put in impound, would that change what we are trying to do with the legislation? Because it sounds like we need all 3 things. We need a person arrested, charged, and convicted. But if we add impound, I think that may change because you can impound a vehicle before you actually have been convicted. So I understand, but I want to make sure we stay in line with what Chairman Nix is trying to do and the great drafting work that Jill Travis with GACTO has done on this.
And Representative Bodie, I know, and several, Chairman Burchett and Chairman Administration, I know y'all haven't practiced as long as y'all have. Impoundment is available to law enforcement in many circumstances. I would tend to agree with Representative Bodie's assessment of that and all, and I am sympathetic to the impoundment, but I think we find ourselves in some of the similar situation we found ourselves in the last subcommittee on this as to whether law enforcement already had this authority. And although I'd entertain that for sure, especially to protect our national forest, I would tend to agree with Representative Bodie on this. However, I would defer to our two other chairmen here if they want to weigh in on it, or Chairman Burchett.
I agree with Representative Bodie. I believe that while it may be in somewhat the spirit of the bill, we need to probably see a separate piece of legislation for what you're wanting. This is having to do with civil asset forfeiture. And I think that it would likely put Representative or Chairman Nix at possibly not being able to get this thing moved in the Senate. I don't know. I mean, I think we move it like this, but that's my opinion.
Thank you, Mr. Chairman. Mr. Herron, I think the best posture for that situation, get with GACTO and PAC and see what we could do on that, because I think that would be another tool in this issue here.
So just follow the number through the process?
Yeah,
Would that be your recommendation?
Yeah,
That's
just
fine with me.
I would make sure that I get with them, because it still seems like that would be a useful tool for law enforcement on the front end of all this. So I would get with PAC and GACTO. And
Well, as I said before, we're not interested in punishing anybody. The offender is not the problem, it's the offense. And the offense is peculiar to the vehicle. Nobody is going to go and run up your property with a pickaxe and a shovel and do this kind of activity. These machines, it takes seconds to do it.
right.
And it's erosion everywhere. It's just tearing up fish beds in the stream. I mean, it's a problem that can be prevented.
Sure.
As soon as people learn that it's going to cost them something, they'll quit doing it. I
Understood.
believe that. But I'm
Understood.
happy to work on it going
Yes,
along.
yes, please do.
Thank you. I appreciate you all.
Thank you. All right. Who else do we have? Okay, I think that's all we've got signed up to speak. I'll entertain a motion at this time. Move to pass. All right. Move to pass in a second. All those in favor say, or excuse me, before I forget, there was a proposed amendment that was submitted to us, and starting at line 19 after proceedings, it would read, you put a comma there after proceedings, and it would say including the reporting requirements set forth in OCGA 9-16-7. And then also in line 19, you would remove the word pending before criminal proceedings. You would remove pending and insert the pendency of. Again, it would insert the words the pendency of. I'll entertain a motion for the amendment. Chairman Burchett.
I motion that we accept the amendment as proposed.
I have motion.
Second.
Motion and second. All those in favor of the amendment say aye.
Aye.
All those opposed? Hearing none. All right, the amendment passes. Okay. We have a motion, a second, or All right, I'll entertain a motion to, okay, all right, we've already got the motion and a second to vote on the bill. Now it would be to vote on the bill as amended with amendment we just passed. All those in favor, let it be known by saying aye.
Aye.
All those opposed, no. All right, bill passes on the floor. Thank you, Chairman Nix. Should have grabbed some coffee before we got over here, y'all. My apologies. All right, next up, we have Representative Holcomb with House Bill 1354.
Thank you, Mr. Chairman, members of the committee. This is the legislation to provide a new structure for addressing issues of compensation for the wrongly convicted. The overall biggest change from current policy is the current policy goes through the Claims Advisory Board, and the meat of this bill begins on page 3 in part 4, and it would set forth a wrongful conviction compensation review panel. And the members, it would consist of 5 members, and this begins on page 4. And these individuals would be appointed, and they would come with the different levels of expertise that would be expected for a panel such as this. And it would include a judge who presides over felony criminal matters in any state court of record, appointed by the Chief Justice of the Supreme Court of Georgia, a current district attorney appointed by the governor. That's a specific new change that I'd like to highlight to the committee from PAC, which was accepted. They wanted to make sure that it was somebody who had experience with felonies and have it to be a current district attorney. It would also include a criminal defense attorney appointed by the governor, and then individuals appointed by the Speaker of the House and the President of the Senate, who also would bring to bear some expertise in this area. It sets forth a standard for this group to evaluate claims of wrongful incarceration, and then it would set forth the criteria for compensation. And with that, the compensation part is up ahead on page 7, and it sets a floor and a ceiling, and the floor would be $50,000 and the ceiling would be $100,000. And this was devised from looking at what is comparable to other states across the country, and also what is comparable from the federal system. And my understanding is in the federal system, the number is approximately $70,000, but many states are right in this line. And so it provides some flexibility within those ranges, but again, sets both a floor and a ceiling. It would also provide for reasonable attorney's fees to assist with this process. And then this group would make a recommendation to the Chief Justice of the Supreme Court. And then the Chief Justice would, if the Chief Justice accepted the recommendation, recommend that the compensation be provided under their budget for the next fiscal year. So there's been a lot of work put into this, but I think that there's a decent amount of agreement in terms of the need for reform, that we really need to update the process from what we have today, which is largely ad hoc. My sense is we'll continue to receive important feedback, which of course we'll carefully consider. But this bill represents an important step forward for these cases. And I'll end with where I began in the last hearing, which is, thankfully, this is very rare. Overall, the system works correctly, and it's the rare exception to when individuals are falsely or wrongfully convicted. But when that happens, there really needs to be a system to compensate those individuals. And this is especially true when they've lost decades of their lives incarcerated and were unable to participate in the workforce, to increase their skills, to contribute to Social Security. There's real harm, let alone their loss of all those years and their freedom when they didn't actually commit those crimes. So I'd be happy to dig into the bill and whatever level of specificity you'd like, but that's an overview, Mr. Chairman.
Any questions from the committee? Chairman Astration.
Chairman, thank you, Representative Holcomb. Really appreciate your work on this. Since we last heard this bill in subcommittee, can you just go through any changes that in the language?
Yes, Mr. Chairman. There were a few that were recommended by the Prosecuting Attorney's Council. One of them is on line 54, and it was just to clarify that an acquittal include any lesser included offenses, just to make that clear that if they had other issues, we tried to make it as sort of clear and clean as possible. And then the other one, one of the biggest ones, was just to have it be a current district attorney, and that's on line 74. And then the other major change is on lines 90 to 94. They provided some clarification to help with the issues of if a confession were later found to be false, that could be overcome by satisfying the proper evidential standard. So those are the main ones that and the last one, I'm sorry, is on line 138, which would be to allow the Attorney General to be entitled to present evidence at the hearing. So instead of it being optional, but if the Attorney General wanted to weigh in, then the Attorney General would have a right to speak.
That's maybe, that last change is maybe the only real policy change from the previous draft then. Is that fair to say?
I agree. I think the other ones were fairly minor overall.
Really kind of clearing up the intent maybe initially.
Yes, sir.
If I could just talk through lines 146 to 147, this may be more of a legal opinion, but is the may language, is that really more discretionary? I understand the basement of 50,000, but how do you view that?
That is a great catch, Mr. Chairman. I would feel comfortable if you wanted to switch it to shall, for sure, because I think the whole idea here is to provide some compensation. So,
well, I'm not,
if that's what you're asking.
I'm not, I'm just trying to understand the language right now. If, I suppose it's just the will of the committee as to what that should be. We also had some discussion offline about the adjusted for inflation language, and I know that you've thought a lot about that. Can you maybe just talk through what your thinking is? Do we have that in other areas of the code? Is that what has your thought process been on that?
Thank you, Mr. Chairman. That's in lines 166 to 170 for the committee, and we have found other sections of the code where it happens. My sense is it makes more sense to keep it in there because it helps to solve the problem that we're attempting to solve, which is to keep this from having to continually come back from the legislature. So by building it in, it gives some flexibility for it just to be increased over time without maybe a political fight about what the floor and ceiling should be. So we have found support for including a change over time, inflationary adjustment. My own preference would certainly be to keep it in, but if there were concerns against that, then certainly I could live with that as well.
All right. Thank you for your work on this. I appreciate answering my questions.
Thank you.
Representative Bodie.
Yes, thank you so much, Mr. Chairman. I would say the Chairman, Chuck Abstration, made an excellent catch in line 146. And if we if the author is okay with the friendly amendment to change may to shall, I'm just concerned that if we move forward with may, that they can go below that 50,000 and say, oh, we have $25,000 a year is good enough for 20. I'm really concerned about that. And I want to make sure Representative Scott Holcomb, you've done a lot of great work on this. And I want to make sure the intent of what you want is what we get out of this bill. And I would not want your legislative intent and our legislative intent as a Georgia General Assembly to be misconstrued in any type, way, shape, or form.
If I could respond, I also feel comfortable with the may, just because I think the board understands what its job is, which is to compensate those that have been wrongfully convicted. So part of me favors greater flexibility for the board, and my sense is, my hope would be that they wouldn't go through, find somebody was wrongfully convicted, and then not want to compensate that person. Like, this just gives some context for them that if they find that a person was wrongfully convicted, they then have a range of dollars that they could consider. And by way of example, one area where I think this could potentially happen would be of the skill level of the individual. If the skill level of the individual was, say, quite advanced, they might want to be closer to the ceiling. If the skill level of the individual was maybe less skilled in terms of employment opportunities, and so they thought the fair basis for the compensation was lower, those would all be types of things that they could take into account. So I'm comfortable with the may. I certainly wouldn't oppose a shall, but just know that if we do that, then it's clear that they have to award money in those ranges, and they would also have to appropriate the attorney's fees as well. So.
Chairman Burchett.
Thank you, Mr. Chairman. Thank you, Representative Holcomb. This, as always, you've got a very detailed bill. I wanted to, here we are again, arguing over mays and shalls, right? So
There's
if
a
we
few
do
of
take
them.
that to a shall, do we need to also take that 149 to an or is the intent to?
It would.
I mean, it's just a recommendation, right? I mean, they're recommending within these parameters 1 and 2, whether it's 100,000 or 50,000 in between there, and then the attorney's fees. So what's the intent? I'm just getting after
that. I wouldn't want to put an or there to answer your question directly, Mr. Chairman, because I think that could lead to a result which we wouldn't want, which would, if it's an or, they could just compensate the attorney's fees. And so we really want the money to go to the individual. And the idea behind the attorney's fees too is that an individual probably really needs legal help with this, because there is a legal standard and there could be some rather challenging legal issues that go along with it. We've tried to temper the exposure to the taxpayers by making it reasonable attorney's fees and expenses. So it's not like the billable hour machine is on autopilot or anything like that. So we've tried to be as reasonable and narrowly tailored as possible. But my understanding, learning from those that do this, is that the attorneys are kind of an essential part of it.
that. Thank you.
You're welcome.
Representative Holcomb, I've got a few questions myself here. Let's go back to line, I guess it's 54 on page 3. And I guess we can have our good friends over at PAC discuss this too, but discuss what the version was before and why these changes were needed to this provision, and specifically the lesser included offenses.
Mr. Chairman, I don't have a copy of the prior one, so I don't know if I could phone a friend and have PAC come up and help me if they're here.
Sure, we'll allow that. Mr. Smith.
Thank you, Mr. Chairman, and I know I've signed up to speak, and I just want to make sure my prefatory remarks get on the record that we are committed to this idea that anyone who is wrongfully convicted and then exonerated needs to be compensated. And there needs to be a process. So we are, Representative Holcomb is a good friend, and we have backed his proposals in the past, and we're on board with this. The whole thing, reason why we're involved is making sure that we are putting something in place that's not giving the promise of false hope either. Something that is a method that will go to compensate these folks that are entitled to it. So that's why some of this changes, some suggestions have been made, and I have a few additional comments. Working off the original version, originally the definition of exonerated, A1B read, had his or her judgment of conviction reversed, vacated, or was granted a new trial and upon retrial acquitted. And the language that got added, and not convicted of any lesser included offenses. And this is the same standard that you have applied for record restriction. That basically, if you're convicted of a lesser included offense, you're not entitled to have the greater offense restricted. And that happens from time to time, that people are convicted of lesser included offenses. And while you can say you were found not guilty of the greater charge, saying that you're exonerated and entitled to compensation because you're convicted of a lesser included offense, I don't think is in line with the spirit of the bill. Does that answer your question, Mr. Chairman?
Yeah, I was wondering why that hadn't been brought up in the previous version of the bill when we heard it last week. It just seemed to be an interesting change to me.
Mr. Chairman, the bill was dropped. The bill was read for the first time or dropped into the hopper and then heard the same day. I received a copy of it in the hearing. So my first chance to look at it was during the subcommittee hearing, and the author and some of the advocates behind it were very gracious to allow me to have a few minutes to speak to them after that meeting.
Right.
So I tried my best to get these suggestions in as quickly as possible. It was not meant to delay this bill at all.
Sure. So is there any hypothetical of where this language would, I guess I'm just concerned about this. Is there any hypothetical that you can think of to where, and this may be more of a policy question, Mr. Smith, really. I'm trying to rack my brain, and maybe Gactel can weigh in on it as well, but is there some kind of hypothetical here where there was a lesser included offense that was committed clearly? I'm trying to think out loud here and just help me with it a little bit. Some hypothetical of where there is a lesser included offense committed, but yet they're convicted wrongly on another charge, or I guess a higher level of charge.
No, I think that the intent was to do the reverse, that basically say someone was not convicted, that they were had their judgment of conviction reversed or vacated or was granted a new trial, and upon retrial, say for instance, someone was charged with burglary, then it was reversed, and when it came back on, I'm thinking of, sorry, my brain's running really quickly right now, and I apologize.
That's fine.
But say someone was found guilty of burglary, they appealed, and for whatever reason, let's say they received ineffective assistance of counsel. So they get granted a new trial, either through the appellate process or through the trial court granting them that opportunity. And then at the second trial, instead of being found guilty of burglary, they're found guilty of criminal trespass, or found guilty of theft by taking. Both of those are lesser included offenses of burglary. The person hasn't been exonerated of burglary, They were just found not guilty of burglary. And without that language about not being convicted of any lesser included offenses, they could then make application and say, I was exonerated of burglary. I was and if they were any time incarcerated because of their burglary conviction while it was going through the appellate process, they would then be able to ask and apply for compensation. That's why I was asking to have that definition tightened up a little bit, because we're not looking, at least my understanding is we're looking for those folks who are not guilty, period.
Exactly.
Those are the people that are entitled to be compensated, not the people that are found to be guilty of something. We're looking for those who were truly exonerated that should not have been convicted of the offenses in the first place. I mean, that, and once again, I hope I'm,
No, that was fair. That was the hypothetical I had in my mind. I just wanted to kind of parse through that. You can keep your friend here if you'd like, Representative Holcomb. I got another question on line 70 for a current district attorney appointed by the governor. Now, I appreciate my prosecutor friends, but my question is, current district attorney, tough on crime. What's that current district attorney's judgment going to be compared to allowing for a retired district attorney to weigh in? I mean, I get it, and I know, I don't want crime in my backyard either. And I love that we're tough on crime. However, I'm sitting here thinking through this, a current district attorney, if you'd just walk us through why that was changed in the bill.
I'm okay with a retired, just so you know, but the PAC's preference was much more for current, and I'll let them speak to that.
it's what the definition of retired is, because we think of retired as being someone who hits their 20 years or their 30 years and then rides off into the sunset. But if you don't receive the majority of the votes in November, you're technically retired as well. And that's what I was thinking of, is that by asking for a current district attorney, that's somebody that is currently accountable to the people, rather than someone who lost an election, could not run for re-election. There's several different ways to be deemed retired. And that's why I suggested current would be a much stronger. And also, to be honest with you, if you look in line, you were talking about tough on crime. The DAs in the state right now are not all, there's a wide variety, and there's a great opportunity to have different voices being heard.
So just walk me through this. Who appoints all these people to this commission?
Well, in this case, the governor would be appointing both the current district attorney and a criminal defense attorney.
And so the governor is answerable to the voters as well, right? And in a Republican form of government, that's how things work. So I get your consternation on the current district attorney who's, answerable to the voters, but the governor who's appointing them is answerable to the people. And whereas, not most of us vote off of one issue, somebody could hypothetically get ticked off that the governor made disappointment of this retired district attorney, and that could be their issue. They vote against the governor on and campaign against him on. So, I appreciate that, but I would point out these people are still held accountable by the voters because the governor is still held accountable to these voters. So I appreciate that. And I would almost suggest, though, that you put a current or retired district attorney. I think that might be the middle ground. Preferably, I wouldn't necessarily think a current district attorney would. I see problems with that. I really do, especially around election year. I really see a problem with that. So, I'll leave it to Representative Holcomb. That seems to be something just hypothetical in this, and going through the whole process. That's what comes to mind of issues going down the road. What I'm afraid of is that we're not having anybody compensated for the time that they've had to serve because they were wrongfully convicted. That's a huge issue for me. Let's see, I did have one other part. You said changing 136, 137, 138. Just walk me through the reasoning, Representative Hawkins, for this.
I'm sorry, Mr. Chairman, what line numbers again?
Line 136 through 138.
Originally, the language was that both the district attorney for the circuit in which the conviction occurred and the attorney general shall be notified of the time, date, and place of the hearing and may present evidence at such hearing. By saying may present, then gives the opportunity that if the prosecutor did show up with it present to make a presentation, they could be excluded. Whereas by saying shall be entitled, still gives them the opportunity that if they feel that it's in the interest of justice and the appropriate thing to do not to make a presentation, they can. But if there is some reason that they feel they need to advise the board of something, then, or the commission or council, whatever we've called this, the board, I guess, that they have the opportunity to speak and to advise the board of certain information that the board needs to know that they may not be getting from the person making the claim. It's the same. It's, once again, it's up to the board to hear it. They can do what they want to with the information, but by changing it from may present evidence to shall be entitled to present, it allows someone who wants to make a presentation to have that opportunity.
Practically speaking, Mr. Chairman, I agree with the change, but my sense is it probably won't happen very often because these are the cases that are really compelling. And my sense is there wouldn't be many instances, but if there were, then there would be a right to present evidence and testimony in contradiction to the request for the claim.
Okay. So y'all's contingent is the shall. Okay, I got you. I follow. Okay. All right. Bear with me just 1 minute. Chairman Burchett.
Thank you, Mr. Chairman. Line 52, do we not need an or at the end of it?
I think there's one after 54, which would by implication apply to 52.
Okay.
No, let's wait and see if they have it.
All right, Representative Bodie.
No, Mr. Chair, just at the appropriate time, I want to make the appropriate motion.
Gackel, do y'all want to speak to this, Ms. Jill?
Just in support, Mr. Chairman.
Okay. No comment on any consternation members of the committee may have had, i.e. the chair. Yeah, sure. Thank you.
I share your concern. I don't know, do I need to introduce myself? Jill Travis, Executive Director, Georgia Association of Criminal Defense Lawyers. Mr. Chairman, I share your concern with respect to the prosecutor issue. I can understand wanting to have somebody that's a felony prosecutor that's engaged in it, and maybe not a municipal court prosecutor assigned or a state court solicitor perhaps. But it seems to me that you've picked up on a good point about the issue of whether or not they're current and the politics that could potentially come into play. With respect to the lesser included language, I would point out that that language is also contained at lines 101 and 102. So in order to get compensation as a requisite, the claimant would have to have been not convicted of a lesser included offense. I think the scenario that comes to my mind might be somebody that at the time of the arrest is in possession of drugs and was also charged eventually with a murder. And it ends up that they were convicted of murder. But of course, drugs are not a lesser included offense of murder, but they were charged with something else and they were guilty of something else, but they weren't guilty of the murder. You would want that person to have the opportunity to get compensation. I would also publicly want to commend Representative Holcomb for having the courage to bring forward this bill and this committee to take this issue up. It has been a long-standing issue. I know that as legislative counsel, I wrote many versions of this, and if I take off my Gaxel hat and just as Jill citizens say, it would be really great to have Georgia have something that's in place that citizens could count on for these circumstances.
Questions from members of the committee? Chairman Burchett.
Thank you, Mr. Chairman. This is actually a question for the author. Thank you, Jill, for testifying. As always, appreciate it. And I know we lean on you for more than just GATCO, but for your expertise in drafting and the years of knowledge you've got doing that. Just a question about 74 and 75. Is there a reason the governor, we picked the governor as appointment officer there, or the appointor?
Yes, Mr. Chairman. The idea was to try to spread it around among the three branches of government because all are involved. So we're involved with the funding. The courts are involved because that's where the wrongful conviction would take place. And then the executive, this new entity would be housed underneath the executive branch.
Okay, thank you.
You're welcome.
Any other questions from members of the committee? Representative Hawking, we discussed the changing of the may to a shall on line 146. And our brilliant analyst, Mr. Brian Hines, who we worked to death, he has if you'll get with him, we can suspend for about 10 minutes or so. If y'all want to get with him, Chairman Administration, I think y'all had mentioned, or Chairman Burchett and Chairman Administration, if y'all want to just get together and write that out real quick and see if you'd be amenable to it.
Sure.
Okay, thank you.
Thank
We'll
you.
suspend for about 10 minutes.
Warn you about putting shall in there.
Yeah, I don't want to do it. It's too.
Yeah, because the problem is, and this is something I haven't had a chance to say to them, was that I told, George, you're telling the Supreme Court, Chief Justice of the Supreme Court, that you're taking, you're trying to chip away more of his discretion. And the more you tell him that he has to do this, the more it worries.
Just a heads up to the author, your mic's still on.
All right, we're gonna go back online here. Representative Bodie, I think you had mentioned about the appropriate time. I'll entertain that now. Chair, Representative Bodie.
Mr. Chair, I move that we pass LC 441965.
Second.
Now that's the old one.
Oh, my apologies, Mr. Chair.
It's the
4422002S.
Okay. All right, moving a second to pass LC 442002S. All those in favor, let me know by saying aye.
Aye.
All those opposed say no. All right, it's on full. Congratulations.
Thank you.
Yes.